Good afternoon and welcome to the Rosalind Franklin Women in Science and Healthcare Seminar Series, Women's Bodies Under the Microscope. It is my pleasure to welcome you today, both those who are joining us in person and those joining virtually. I'm Christine Burgess, an assistant professor and director of didactic education for the Rosalind Franklin University of Medicine and Science Physician Assistant Program and a co-chair of the Women in Science and Healthcare Symposium at our institution. And I'm happy to welcome you to our seminar today. Are women still people under the Constitution? Reproductive justice, women's personhood, and the contemporary abortion debate with Dr. Katie Watson. In the words of my co-chair, Dr. Lise Elliott, from our WISH Symposium in October, this year's theme, Women's Bodies Under the Microscope, hit us like a bolt of lightning on June 24th, 2022, when the US Supreme Court overruled Roe v. Wade and half the population suddenly lost a profound constitutional right. We knew we had to put the issue of women's bodily autonomy under the microscope. This year's theme of women's bodies under the microscope kicked off with our fall symposium speaker, Dr. Paula Johnson, Wellesley College president and cardiologist, who discussed gender and racial health disparities. I cannot think of a better speaker to continue our theme for this year, so I'm thrilled to welcome Dr. Katie Watson to speak today. Dr. Watson will be introduced momentarily by Dr. Regina De Leon Gomez, whom I'm excited to welcome today. Dr. De Leon Gomez is an OBGYN and medical school grad of Northwestern University Feinberg School of Medicine. She's an assistant professor in the Rosalind Franklin University of Medicine and Science, Chicago Medical School, serving as a course director for the Clinical Foundations of Medicine. Dr. De Leon Gomez's clinical practice began as a lieutenant commander in the U.S. Public Health Services caring for Indigenous women. Her then 20-year career as an OBGYN hospitalist allowed her to both care for the underserved at the bedside and lead numerous quality improvement and perinatal safety initiatives as the medical director of the OBGYN hospitalist program at Northwest Community Hospital, part of North Shore. Additionally, Dr. De Leon Gomez is passionate about bioethics and is currently enrolled in the Northwestern University Feinberg School of Medicine's Clinical Bioethics Scholar Program. Our seminar speaker, Dr. Watson, lectures in the bioethics program, and thus Dr. De Leon Gomez recommended her as our seminar speaker today. We are so grateful for her recommendation. Finally, on a personal note, I'm absolutely thrilled to introduce Dr. De Leon Gomez, as she was my professor in my OBGYN course in physician assistant school, and I'm grateful she imparted her knowledge to help spark my interest in women's health. So please welcome me in joining Dr. Regina De Leon Gomez.
So thank you, Christine, for your kind introduction of the introducer. I get the fun part. It is my privilege to introduce Professor Watson to you today. So Katie Watson is an associate professor of medical education, medical social sciences, and OBGYN, and is core faculty in the medical humanities and bioethics graduate program at Northwestern University's Feinberg School of Medicine. Professor Watson is a graduate of NYU School of Law, where she held a Hayes Fellowship in Civil Liberties and Reproductive Freedom. After law school, she clerked in the federal judiciary and practiced public interest law, then completed fellowships in clinical medical ethics at University of Chicago's Medical School and medical humanities at Northwestern. She then joined the Northwestern faculty. Professor Watson's articles on abortion ethics and practice have appeared in publications that you might have heard about, including JAMA, the New England Journal of Medicine, the Lancet, and the New Yorker. She is the co-editor of Reproductive Ethics in Clinical Practice and is the author of Scarlet A, The Ethics, Law, and Politics of Ordinary Abortion, which the New York Times Review described as revolutionary. And it was recently recommended as one of 10 books to understand the abortion debate in the United States. Additionally, Professor Watson is a member of the Northwestern Memorial Hospital Ethics Committee, the Ethics Committee of the International Federation of Gynecology and Obstetrics, FIGO, and the Planned Parenthood National Medical Council. She is a former member of the boards of the American Society of Bioethics and Humanities, the board of the National Abortion Federation, and the editorial board of the AMA Journal of Ethics. Let us now give a warm welcome to Professor Katie Watson.
Thank you so much for having me today. If this popped up as one of those "I'm not a robot" CAPTCHA tests, I feel like you would all be very confident and fast clicking that plants, animals, and rocks aren't in the biological category of human. You might stumble on the cells, but I gave you a hint about the DNA of those cells. So you understand it would result in a human baby, not a tiger cub. So you would know to check that. It's a biological category. We have no debate about the category of human. If I asked you to check who is a person protected by the US Constitution, I hope everyone would check the two portraits with an understanding that this has changed over time. If it were 1789, Elizabeth Freeman, an enslaved woman who lived at the same time as Thomas Jefferson, does not get a check in the box. If the year is 1868, after the federal 13th Amendment abolishing slavery has passed, and the 14th Amendment federally guaranteeing that you won't be deprived of life, liberty, or property without due process, there's no question Ms. Freeman's descendants are citizens with all the rights that entailed. Constitutional person, check. All right. And whether you're a person in the eyes of the law matters very much. For those of you who have not heard of her, I want to share with you the fact that Elizabeth Freeman is a woman worth knowing. She was a midwife and a nurse who was enslaved in the home of a Massachusetts lawyer, John Ashley, who was fighting the British in the Revolutionary War. Captivated by the phrase in the Massachusetts Constitution that was being debated, all men are created equal, and by some accounts enraged by the phrase, all men are created equal, she sued for her freedom in 1780. And the reason she could do that was Massachusetts had a very unique law defining her as both property, but as a person as well, so that enslaved people could sue to challenge the person who alleged to be their owner's ownership. So she was allowed to sue, and in part because of her case, 10 years later, Massachusetts was the first state to abolish slavery. So whether your person matters very much. And my premise is that 7 months ago, when the Dobbs case was decided and reversed Roe versus Wade, we all know that part, but that Dobbs is about more than abortion. As Justice Kavanaugh put it during oral arguments, you have to pick. Abortion is so challenging, I think, because either the interests of the pregnant woman or the interests of the fetus have to prevail over the other. When you have these two interests at stake, and both are important, Justice Kavanaugh asked, why should this court be the arbiter rather than the people being able to resolve this? Why is this not the right answer? Well, Justice Kavanaugh, ruling that it is not unconstitutional for state legislatures to pick a blastocyst embryo or fetus over me is not the right answer, because a woman is a constitutionally protected person and an embryo or fetus is not. Therefore, the Dobbs ruling that a state may prioritize those entities over the adult person in whom they live is the Supreme Court has done something profoundly regressive. Scholars of the legitimation of social inequity explain misrecognition serves the interests of the powerful because it allows their interests to be achieved surreptitiously. So today, my goal is to simply put this idea that Dobbs is more about women than abortion on the table for your consideration. Who is a constitutional person? Well, it's important that we go back a little ways, and my students are always shocked to learn that in 1965, states criminalized contraception, and then through 1972. So Griswold is the famous case that developed the privacy doctrine. It wasn't Roe, it was Griswold. saying there's a zone of privacy. We have cases from the 1920s. We didn't use the word, but that's what it was talking about when we put these amendments and the constitutions together, a zone of privacy in the home, and in this case, the marital relationship, in which the government may not enter to decide whether your sexual relationship must or be or not be procreative. That's your business. Eisenstate in 72, the states could have just said, oh, the jig is up, and they rewrote their statutes to say, okay, well, single people can be penalized for sex with pregnancy. No, you can't criminalize that. And this is the bumper sticker quote from Eisenstadt. Now, in Roe, in 73, a year later, the question was, does this conclusion apply even in the presence of an embryo or fetus? And the court doesn't get enough credit for writing quite a originalist intent opinion that says, well, there's 16 uses of the word person in the Constitution, and none of them could possibly apply to embryos or fetuses. So we have to say the framers, and I think this is hard to contest, weren't thinking about this issue when they wrote the Constitution. And then they did a sort of balancing to think, okay, well, let's look at the interest on the other side. And essentially they said, and I really want to underscore this, the idea that we are not here to make any statement about the moral status of embryos and fetuses. That decision maker will be the individuals. It will be the pregnant person or the pregnant person in conversation with her partner or her family or her faith or whoever is in her community, her world. It won't be us deciding for her. That's not how this typically works in the United States. And then we get another sort of free, they don't use the word conscience, but the same privacy and liberty sort of language in 92 when the Casey court affirmed this, saying, we're not saying anything. Abortion's good, bad, otherwise people will make up their minds and do what they do. But what we're saying is, and this is the bumper sticker quote at the bottom, our obligation is to define the liberty of all, not to mandate our own moral code. This exact sentence is repeated in Obergefell, the case that decides that there's a constitutional right to same-sex marriage, right? And again, it's a similar kind of language of like, you decide who to invite to dinner and you decide how to live your life, but the government may not legislate these issues of morality. So jump forward to Dobbs. They reverse Roe and Casey and they say, well, this is really an originalist analysis that legal abortion wasn't part of the history and tradition of the United States. And so we're not convinced by this textual framing. It's not protected under and this is not a law school audience, I'm not going to go into substantive due process, but the idea of, think about that due process clause, life, liberty, and without property without due process, the idea that that's not just procedural, there's something else larger about that, the substantive due process. That gets us into the police in your bedroom for contraception concepts and larger issues. So why is that? But does that mean that the contraception and gay rights cases, which are also premised on substantive due process, are going down as well? Well, Justice Thomas says, yes, they should. We got to reconsider all of those for exactly the same reason. It has been writing for years in dissents that these need to be overturned. The majority says no. Don't worry about those other cases. What distinguishes the abortion case line is that abortion terminates a life or potential life. Now, this is really important, but it does not explicitly say we are granting constitutional personhood to embryos and fetuses. And I've long thought that that would be the only intellectually honest way to allow any kind of governmental ban on abortion, was to do an amendment, just like the Reconstruction amendments, do an amendment that says we have our moral concepts are no longer an issue of pluralism. We have consensus. We are not going to do this anymore. We're going to treat everybody alike. That would be an intellectually honest way to do it. Justice Thomas, though I passionately disagree with him, is being intellectually honest. It's a whole area of a whole approach to jurisprudence that he says it's got to go no matter what the topic. But the majority says the presence of life or potential life is the difference. But it doesn't grant personhood to embryos and fetuses. It couldn't textually. So it had to, something else has to give. And my argument is what it did is downgrade the personhood of women to allow this possibility, right? Because when Justice Kavanaugh says in the oral arguments, and I just find these exchanges so interesting, he says, well, this is what Mississippi's arguing. If we take a scrupulously neutral position, There'll be different answers in Mississippi and New York, different answers in Alabama and California, because the people might value those interests somewhat differently. Well, what interests? The interests of a blastocyst versus the person in whom it lives, right? And I want to be careful here that I don't say too much visually with this analogy, because I have a portrait of a woman who was enslaved, and I do not mean to say slavery is the same as, it's not the same as anything, right? It is a uniquely horrific institution in its history and its comprehensive capture of a person's body that is often for infinite, for their entire lifetime. I will say I am really interested in scholarship. Andrew Koppelman and Michelle Goodwin are the two of the primary scholars who argue the 13th Amendment would be a different textual basis for saying that abortion is a constitutional right, because this is the state capturing your body for the benefit of another person against your will, at least for that 9-month duration. I think that's a really interesting area of scholarship, but I want to be careful about extending this kind of analogy. I do want to just share with you how troubled I am by this map. When Kavanaugh says the people in Mississippi and Alabama are going to do it differently than New York and California because they value those interests differently, that just has a ring for me. That if they were reversing Brown versus Board and they were talking about segregation and saying, oh, nowhere in the Constitution does it say separate can't be equal. It just says equal. So we're going to reverse this. And people in Mississippi and Alabama might see it differently. Would anyone be confused that that would be an utterly false neutrality and that would be incredibly regressive? And then when I look at this map and the darker colors are the states that have banned abortion, it's not a perfect lineup, but it's rough. And I wonder about this historical legacy of the control of bodies. So again, I'm not saying the institutions are the same, but I think being informed by history is relevant. So I just leave this for you, whatever you choose to make of that. I think the question on the table is at some level an incredibly complicated one and another very simple. Must biology be destiny? Right? And we rarely think of abortion as a technology issue. You know, in bioethics, I'm always teaching about ventilators and dialysis and how technology changes questions of who's alive and is it murder to take someone off a ventilator? Is that suicide to refuse those antibiotics? But abortion, though it's been with us forever, safe abortion and effective abortion, reliable abortion has not been with us forever. That is a relatively recent invention between antiseptic technique and antibiotics and our brand new pharmaceuticals, historically speaking, of medication abortion. And its safety is also a product of its legality, because we could do research and disseminate information and perform abortions in safe medical spaces, right? So that is relatively new. And I want to argue to you that that is relevant to this analysis. So I am a former fetus. You are a former fetus. And I reject the claim that anyone speaks on behalf of fetuses more than another person, right? Like, I think we all have a skin in this game. We all have different reproductive aspirations and capacities and experiences. And I think I am a big fan of pluralism in this space. And I am genuinely respectful of an incredible range of opinions and choices. And so when someone comes to our hospital and says, you recommend I end this pregnancy because it's threatening my life, but I just wouldn't be who I am if I did that. I am the ethicist who's like, give her all the $1 million medicine we have, right? And if someone comes and says, this does not fit my values and my life and my light, I'm going to follow my own light. I'm the ethicist who says that is that person's path, right? But I want to say, we talk about how so for me, those who oppose legal abortion, which is very different than opposing abortion itself as a procedure, right? I wish no one would have one versus I want the power of the state to use the criminal law to prevent anyone from having it. I think those are different views. But those who oppose legal abortion had 49 years to change hearts and minds, and they weren't able to. So now they're using the force of the criminal law to try to do what they couldn't accomplish through persuasion, which troubles me as a First Amendment advocate. Because it turns out Americans love contraception and abortion. We say we're very conflicted, but in all my work, I follow the body. I'm less interested in what you tell Gallup than what you do when confronted with an unwanted pregnancy. And I apologize, in 1800, the only data collected was for white women, but the average was 7 births per woman. 2020, it was 1.64. We don't have perfect data about the age of first childbearing, but we know this is much later than historically. And the fertility of the groups are going down, that we have a higher fertility in our older age group. How did we do that? Okay, well, we use a lot of contraception and we use a lot of abortion in the United States. And you could say what's too much, or you could say some people don't have access, so it's not enough. We can debate numbers later. But the fact is that in 2020, 1 in 5 of all US pregnancies ended in an abortion. Someone chose to end that pregnancy, and that's exclusive of miscarriages. If you just look at unintended pregnancies, it's 42%. And that's the best data we have. We don't distinguish between unintended. Many of us are that third whoops baby who is entirely welcome, unintended, but not unwanted, versus truly an unwanted pregnancy. But 42% of unintended are terminated. Abortion rates before Dobbs were at their lowest since Roe versus Wade. The advent of IUDs and more effective contraception and ACA coverage was reducing the abortion rate. But so in women in my age range, 1 in 3 of us have had an abortion. 1 in 4, if those rates remain steady, would have one in the reproductive group today. So it's popular. I think it's hard to debate. Whether that's okay with you is a completely different subject. And I want to be very clear, they're doing it by criminalizing medicine. So here's that map. I just chose the Washington Post. There are several, but I have an asterisk here. I don't think the headline is correct. Abortion is now banned. Abortion isn't actually illegal in any of these states. The provision of abortion is illegal. The doctors, the pharmacists, the nurses, the techs, that is who is criminalized. So it's saying you can't take this information, you can't take this medical technology and use it the way you might have liked to. So maybe, if you're like me, you've had a little trouble sleeping recently, but because I work with physicians, but maybe we shouldn't be so surprised, because historically speaking, women's personhood under the Constitution and through law and culture is relatively recent. So let me do a very quick review to remember our historical position. Of course, we cannot speak of women as a monolithic group, because depending on race, even the aspiration of constitutional personhood was different. So we've already talked about the change in 1865. But it's important to remember, even before that, I would be the property and the legally subsumed under my father and then my husband. Can't hold money in my own name, can't sign a contract in my own name. I'm not, the Seneca Falls Declaration put it well, I am civilly dead, right? And that changed through state legislatures over the course of a half century. I'm going to chat with you about Bradwell versus Illinois, a terrific case I love to hate. And it's really important to remember we've only had the vote for 100 years. Right? Like, again, long time, historically speaking, not so long. And it's interesting that very liberatory 14th Amendment is the first time that gender appears in the Constitution, because males were guaranteed the right to vote over 21. So men of African descent could vote, but women of no color could vote, right? And that was the clarifying, putting gender in the Constitution. All men are created equal. People like Elizabeth Freeman could claim meant her too, not anymore after the 14th Amendment. And then a case I'll share with you from 1961. So Bradwell versus Illinois. Mrs. Bradwell, and it's really important to have the Mrs., is an Illinois lawyer. So this is close to my heart. She wants to practice law. She's gone through law school. Her husband has a legal practice, but women can't get licensed as lawyers because they can't sign their names as a contract to have someone as a client, to have that fiduciary and confidential relationship that involves a money exchange. So she can't be licensed as a lawyer. So being a really good lawyer, she takes her case to the Supreme Court. She doesn't get to argue it, but she drafts the paper. And the Supreme Court rules against her and says, well, this is kind of an administrative issue. We're not going to get into how the states license professionals. But 3 justices just can't stand it and feel compelled to write a concurrence. Basically just screams, it's because she's a girl. So they give a wonderful summary of what's called the 2 spheres philosophy. Basically, the very clear idea that women are meant to reproduce and be wives and mothers and be in the private sphere at home, and men are meant to be in the public sphere. And that's just the way the Creator has made it, and our laws have to fit this, right? And you think, okay, 1872, that was a long time ago, Watson, you're a lawyer in Illinois, get over it. But flash to 1961, Mrs. Hoyt was charged with murdering her husband, and she was convicted by an all-male jury. Now, this is right after the Supreme Court has been on a hot run saying you can't have all-white juries convicting Black men. That's a violation of the Equal Protection Clause. Those are not juries of their peers. And so she says, oh, that seems like it would apply to me too. Nope. Florida only calls men for jury duty. And the court says, we're really groovy. It's 1961. Women are doing great. But they need to be home with the kids. We can't expect them to participate in civic life. That's not an equal protection violation. So Florida said women could volunteer. They could show up and volunteer. Guess how many women, showed up to volunteer for jury duty? But they said that's okay, because then if they volunteer, they're determining that service is consistent with their own special responsibilities. Like, I can't not whisper that. In my house, that's just called parenting. So we have a hot run of legislative action here. And look, this is a 30-year bookend where 63, you can't pay us less just because we're women. 64, you can't not hire us just because we're women. The contraception cases happen there. And I think that's not an accident, right? That they didn't happen in 1932. They didn't happen in 1992, right? There's something happening here. Also, the FDA has approved the pill in 1960. So suddenly woman-controlled, need to go to a doctor to get it. Contraception matters more and more. You can't keep us out of school just because we're women. Oh, look, we get the abortion right. You can't fire us because we're pregnant, which was a common practice. Okay, you can have a job, but then once you're pregnant, you're out of the workforce. We affirm Roe, and then a year later, this is the most revolutionary. Hold our jobs. We're coming back, right? Like, we're going to have a child, and we might just come back to the old job we had. The division of the two spheres, that you can flow between home and family and work, and the public sphere, just as men have done from the beginning, right? That we could do that. So we have 30 years of that. Then we have 30 years to see the effect of that, which you see in your medical school and PA and all your other classrooms and in the workplace, in our public life. 30 years of that in action. We see the impact of that in our society. Then we take away the abortion right. I don't think this is an accident. So there is a really interesting equal protection argument that maybe some of you have heard of. You know that Roe anchored the abortion right in a privacy rationale in 1973. But in 1984, 11 years later, two kicky young lawyers, Sylvia Law, who was representing poor women and working on access to healthcare, and Ruth Bader Ginsburg, who was representing women and working on access to employment, independently wrote law review articles arguing that reproductive freedom should be treated not as a privacy right, but an issue of gender equality. As Professor Law put it in her article, abortion bans raise equality concerns because state control of a woman's reproductive capacity and exaggeration of the significance of biological difference has historically been central to the oppression of women. And an equality doctrine that denies the reality of biological difference in relation to reproduction reflects an idea about personhood that is inconsistent with people's actual experiences of themselves in the world. In Dobbs, a group of scholars submitted a brief saying, well, you don't like privacy, you need to reckon with equal protection as a new basis for thinking about this right. The court dismisses this claim in less than a page based on precedent. It's squarely foreclosed by our precedents, citing two cases with this new theory addressed. So Roe was a 49-year precedent, and you disagreed with its reasoning, so you're going to overturn it, but you won't give more than a page, and you just say, well, that's a precedent. We're not going to talk about equal protection. Not impressive. And what's less impressive, I just have to tell you about the Geduldig case. Again, it's a love to hate case. Geduldig said California has a disability, employee disability program, and they explicitly exclude pregnancy in it. And the court ruled that that didn't violate equal protection. And this was their reasoning, that the disability insurance program divides potential recipients into two groups, pregnant women and non-pregnant persons. While the first group is exclusively female, the second includes members of both sexes. Some women are not pregnant, so it's not gender discrimination. That's the Geduldig ruling, okay? You can guess my problems with that. So imagine these two rooms, right? Well, sure, the room of non-pregnant people is larger and has both women and men in it. But let's note two things. At least 85% of American women will have a baby by the end of their reproductive lives. So the women are cycling in and out of the pregnancy room. 85% of them will visit the pregnancy room at some point, and 0% of the men will visit the pregnancy room. And I want to say a note about language. You will hear me use women and people interchangeably because I want to be inclusive of anyone who has a uterus but may or may not identify as a woman. But at the same time, in this lecture, I really want to focus on the gender discrimination that I think is the source of so much of this. So I am going to use the word women and woman quite a lot. So I think this is not an impressive analysis. Just substitute menstrual hut for the, like at work. And you're like, well, they go in the menstrual hut, but it's a menstrual thing, not a lady thing, because a lot of ladies are not in it. So done, stamp. Was that analysis. The American workplace wasn't made for women's bodies, right? It wasn't. This is an argument. Well, why not? And in 1974 saying, because you're complicated and expensive. So I think many of us realize this isn't working, right? We need a new framework. And so I want to shift gears here and talk a little bit about reproductive justice as a different framework for thinking about some of these issues. Will you raise your hand for me? I won't call on anyone. If you have a cocktail party basic understanding of reproductive justice as a framework? Several of you. Wonderful. Okay, great. So reproductive freedom is what I was taught in law school. And that is the classic negative right, government stay out of my bedroom, leave me alone. That's reproductive freedom. And it is focused, as you saw in those cases, on the right to not have a child, the right to use contraception, the right to have an abortion. Women of color in Chicago, we can be very proud of this. In 1994, the representatives of Hillary Clinton came around looking for support for the Clinton health plan. But the Clinton health plan had already eliminated the draft reproductive care to not be controversial. And these women were like, why are you asking Black women to support this plan if reproductive health care is a primary point of contact with medical care? You've already cut us out of your plan. I don't think, I don't know why we should be fighting so hard because you're not even including us right now, and women in general, but women of color in particular. And they developed this reproductive justice concept to say, well, this is the reproductive freedom is sort of a middle-class white lady approach. And in 1997, this wonderful group in Atlanta, Sister Song, was established. Now there are many reproductive justice organizations. Their approach was, well, our historical experience is that we have a history of forced sterilization and forced contraception and the separation of families. And so we also need a right to have children. It's just as important as our right to not have children. We also need a right to parent those children with dignity and not have our families destroyed by the foster care system for the crime of being poor, or have our young people killed in violent neighborhoods and not be educated equally in our public schools. And so the three pillars, sexual autonomy and gender freedom, was added 20 years later. And the idea was, if you center marginalized people, so you look at lived experience and you say, right to not have a child, right to have a child, right to parent the children you have. They're equally important and all must be attended to. And if you center the historical and contemporary experience of marginalized people in your policy making, everyone will be taken care of, versus only thinking of like, what do middle-class white women need, which is going to leave some people out, a lot of people out. And this has been very important to my work. And I want to turn this back to the abortion context and talk about lived experience. Who are most affected by abortion bans? Not everybody understands that half of abortion patients are under the poverty line. These are people who have just over $1,000 or less in monthly income. 62% of them are non-white, as opposed to 40% in the youth population. So women of color are overrepresented and poor women are overrepresented. Why is that? Why don't we talk about access to abortion as a healthcare disparity? This is an article I published this summer. We've got gender, race, and class. This is just sort of a classic hypertension, diabetes, COVID kind of analysis, but we never talk about abortion in this way in terms of access. And I think one of the answers is abortion exceptionalism, this idea that abortion is so different than anything else in medicine We just can't talk about it in any ordinary way. Why are women of color overrepresented? This is not the only reason, but the primary reason is the tragic overlap of race and poverty as a result of structural racism. And so we see this factor playing out, but it's also an interesting issue when we just focus on the economics. Women with incomes under the poverty line have 5 times more unintended pregnancies. So it makes sense that they would need more access to abortion services. So think about the ban on Medicaid coverage for abortion services. Who is most affected by that and who is least able to come up with $500 in cash for a medical procedure that is time sensitive that they need right away and might have to travel for, right? So the penalty of these bans is particularly carried by people in this income category. What this means is the need for abortion is increasingly concentrated among poor women, but the statistic that is never discussed in my experience is that higher income women end a higher percentage of their pregnancies. So in my income bracket, 30% of pregnancies are unintended. We terminate 48% of them, about half. Under the poverty line, 60% are unintended, and that group terminates 38% of their unintended pregnancies. Is this a difference in values? Is this a difference in access to healthcare, right? Is this a difference in feeling like, well, it was unintended, but what's going to be different 5 years from now? Because I'm living in sort of a structural trap where my life might not be better in 5 years. I might not be better situated. We don't have research to tell us, but a wonderful and ethical natural experiment would be to repeal the Hyde Amendment and find out. Why are the 1 in 4 women ending a pregnancy? I'm just going to quickly review. They could check more than one answer here, but that the idea that can't afford a baby now is one of the top 2 answers. And when asked the most important reason, we get to this, that can't afford a baby is very high. This is sort of, again, the classic white feminist, I have to finish college, I'm on a career track, and that's great. And I'm not here to judge reasons for abortion. I just think it's fascinating that for only 4%, that's the most important reason versus economic reasons or my ability to parent reasons. Now let's think about abortion and mothering. This is also something that when I got into this area of research and advocacy and work, I didn't know about. And it was so striking to me when I taught my first med school class on abortion. I looked up these statistics on who has abortions and how often it happened. And I was just shocked. And I thought, how is it I've been teaching the constitutional law of abortion, but I never was taught or understood the epidemiology of it, right? That was just a huge gap in my own knowledge. Perhaps most surprising is that 59% already have a child. Mothers is not who I pictured in the waiting room of clinics, and it was eye-opening for me. We also talk about these, and this is how epidemiology works, as individuals, and they are for decision-making and medical purposes, but I am interested in the fact 88% are dating or married to the man they got pregnant with, right? That to remember that this happens in the context of love and sex and relationships and romance versus this isolated kind of thing. So for me, I was asking myself, well, think about reproductive justice. We talk about the right to not have children and the right to have children as if they're separate things or different times in your life. But this helps to understand how one might go back and forth, right? And so I'm not saying my work is so great. I just am saying, please come join me because there's lots of room to publish here. There was only one study in the literature looking at how family formation might affect abortion decisions. And that is just our scholarship totally disconnected from lived experience, right? And the study that existed, I showed you that big Guttmacher study of like over 4,000 women, their reasons for abortion. They picked maybe 40 to do in-depth interviews with, and they didn't ask them about motherhood, but 38 just volunteered how motherhood and existing children or their hopes for future children played into their decision-making. So there was a secondary analysis on a qualitative paper. So here I had the opportunity to look at years and years of spiral notebooks at an abortion clinic where they just set out and told patients, write whatever you want for other patients or for yourself. It was like you could journal before or after your procedure. And a student and I analyzed 394 entries. And over 7 years. And what we found was half of them talk about mothering as a factor in their abortion decision, even either the children they have or future children. And I just give you two sample quotes, one from someone talking about existing children and one talking about a future child. I'm also really interested in the idea of adoption. And, you know, the Amy Coney Barrett argument that why don't you just drop the baby off at the fire station and then lean into your corporate job? It won't be a problem. You'll have no problem with motherhood. That's actually not how life works, newsflash. And I'm interested in two studies. These findings are just like buried in the studies. But here, 38 women in a different Guttmacher study say they considered adoption, but they thought it was morally unconscionable. They had a different feeling of obligation to a child they had born, that it was their job to take care of it. It would be immoral to ask someone else to do it and, you know, not know whether the child was safe. Similarly, the Turnaway study is amazing. They oversampled among women who were right at the gestational line and they got turned away from clinics. So this is the definition of an unwanted pregnancy, right? You went to an appointment intending to have an abortion, and then you were told, "Ooh, your sonogram looks like you're a little past our clinic's line." The group that couldn't get an abortion, couldn't make it to another place, you'd expect a lot of them would place that infant for adoption. Only 9% did. The other 91% said, "No, that's my job now." And I thought this was really interesting. Some of them said adoption was an abdication of responsibility. For others, adoption became unimaginable once they bore the child, right? So for me, I call this the moral seriousness of motherhood. I'm not saying that abortion isn't morally serious. I'm just saying we ignore in the United States the other side of what is so morally serious, which is the decision to create a whole nother person and bring it into the world and shepherd it. And a theologian named Virginia Rainey Mollenkott calls this a covenant of caring. And I think her words are just beautiful, that what pregnant women are considering is this physical care and psychological attention and tender affect that you make a covenant with a child that is lifelong to provide. So you have to determine, am I up for this? Can I do this? And that's the part of the mothering decision in abortion. And some would argue, well, you know, life begins at conception and a blastocyst in an embryo is the moral equivalent of a child. And while I'm respectful of that argument for anyone who believes that and lives their life by that, as a collective policy matter, I find it hard to believe. I think it's a Trojan horse for an anti-woman argument, and here's why. The Annie Casey Foundation, reproductive rights are not on their list. They're exclusively child-focused. You could pick any number of these kind of maps. This is their 2022 report on child welfare in the United States. And I am troubled by how the abortion ban states line up with the worst child welfare states, right? Like pick one, team, pick one. I spent way too long making red boxes to not share them with you here. But what I noticed when I did this analysis was 75% of states in the child welfare fourth quartile have passed abortion bans. And 75% of the states in the first and second quartile protect abortion. This doesn't line up, right? You know, in the way that some of the rhetoric would make you think it should. So I think there's something else going on here. So I'm going to do a run through. Where are we now? Well, women are resisting state control and they are traveling. An incredible number of women are traveled, and we have very preliminary data from the first few months. Illinois is a state that receives very many patients. And they are also doing abortions at home with self-managed abortion. This is some advocacy political art from Shout Your Abortion, We Will Save Us. These are not websites I'm advocating, but these are websites people go to get medication abortion from international pharmacies. At clinics, medication abortion, which causes essentially a first trimester miscarriage before 11 weeks, was used in 54% of abortions in 2021. So it's already the majority. It's very safe to use at home. And so a really amazing study by the Society of Family Planning showed that abortion by clinicians dropped by 6%, April to August, so 2 months after Dobbs. But we don't know how many of those patients were using SMA. And my answer is check the birth rates in 9 months. That's the only way we'll know what that number is. So women in these states, think of it, Roe was 49 years old, and we think of the end of reproductive age as 45. All of the women of reproductive age grew up with legal abortion in America. And that map tells me they're saying no thank you to these state policies and finding by hook or by crook, and in desperate circumstances, I don't mean to make light of the horror of the travel and the expense, are finding a way to resist this. And the group that's left behind, the 6% is 10,000 people. It's still a large group. Again, we don't know how many used SMA, are going to be the most vulnerable. The people who just had no other option or the health literacy and the access to figure out self-managed abortion. So even if that number's low, I care very much about that number. Some states are protecting women, and I think we have to remember the glass half full, and that we live in one of them. We have a Reproductive Health Act. So when Roe was overturned, we woke up the next morning with nothing changed because our legislature had codified Roe and had also done other progressive things like made our Medicaid coverage equal. So it doesn't matter what your reason is for having an abortion, or we don't ask you why you're having a child either. We cover it, right? And we do that here now. We have private insurance equity, and the Parental Notice Act was repealed last summer. So I understand that abortion is a very stigmatized topic. I just want to say I'm so comfortable discussing it because I always feel like I'm comfortable discussing abortion. I don't need the second reason, but I'm comfortable because I feel like I'm discussing so much more, right? I'm discussing pluralism. A state that can ban abortion, which is a policy of mandatory childbearing, can also force abortion or force sterilizations and have policies of mandatory childbearing. I am arguing for a position of government neutrality, which means you and your healthcare provider get to decide your moral positions in this. And to me, abortion is a very important issue, but those are larger values. So I've been talking a lot about history. Let's end on slightly more recent history. Raise your hand if you've heard of Catherine Switzer. A couple of you have. Awesome. Okay, 1967, a year I'm going to call recent because it's the year I was born. Before 1970s, women were thought to be incapable of running marathons. They were advised that their uterus would fall out. Very literally. Medicine is so great. Catherine Switzer was a college student. She said, hey, let's risk it. And asked the college running coach to coach her because she was a runner and really wanted to run a marathon. And he said, well, train with me. And if you show me you can run 26 miles, I'll take you. And she ran 30 miles one day and left him in the dust. And he was like, yeah, I'll take you to Boston. And so her boyfriend was a college football player. And he said, well, if she can do it, I can do it. And he didn't train, he just ran. And came. So they show up in Boston. And I think it's interesting to know that if Catherine Switzer and her boyfriend had been sexually active, the Boston Marathon is in Massachusetts, so they couldn't have illegally used contraception when they were there. So she goes into the race, and this guy, Jock Semple, is one of the administrators of the race, and he's on a press truck. So it's like this flatbed thing with cameras. So there's lots of cameras of this incident. And all of a sudden he notices there's a girl here. And he jumps off the press truck and attacks her. And it's just kind of unbelievable to think today. But he jumps out and he yells, get the hell out of my race. Think about that, my race. There were no official rules banning women. It was just understood they couldn't do it. And she signed up with her initial, K. Swetzer. It's always how she wrote her name. So she got her number. Her coach then starts to argue with him. And look at this photo. Arnie Briggs is yelling, leave her alone, Jock. I've trained her. She's okay. Leave her alone. And this is all from her autobiography. And this is the negotiating between two old white men. And this is how some of us got to our positions. We had a patron who said, you know, this person of color, this queer person, this immigrant, this woman, they're one of the good ones. They're with me. Come on into my lab, right? Like some of us got here this way. But Jock Semple wasn't going for that. He wasn't going to do it. And so her boyfriend, Tom Miller, executes a crossbody block because he is a football player and knocks Semple out of the way from attacking his girlfriend. And I got to say, this seems to me, and it's so exciting as an older professor, to watch the move of this empowered younger generation. They don't stand and debate discrimination. This is an ally who doesn't negotiate with discrimination. They stand up and block it and knock it out so you can run. And this is what physicians do for their patients every day. The central figure here is the woman who says, I decide what to do with my body. I decide what role I'm capable of playing in society. All she wants to do is run her own race, but she needs your help. So you and your teams do the medical version of what Arnie Brigg and Tom Miller did, which is respect your patient's autonomy and moral agency, clear the obstacles, buffer them against discrimination, and let them just sprint out of your office and succeed or fail on their own terms. So Arnie yells, run like hell. And now it's a 100-yard dash. And Switzer runs like hell for the next 25 miles. So she does great in the Boston Marathon. And I just want to leave you with two happy images. The first, and I'm not advocating violence, but this is just how this one worked out, is Jack Semple doing a jig out of there. Like he's just irrelevant now because he has been crossbody blocked, which she later learns. It's a very elegant move to touch no one but the one person you're trying to get across here. And the second image is Switzer, right after she became the first woman to finish the Boston Marathon wearing a registration number. Her feet are bloody. That's why her shoes are off. Her feet are hamburger. But her uterus is fully intact. So Kay Switzer thought her race was over that night, but she went on to advocate for women being allowed to run. And in 1972, the same year as Eisenstadt, when she and Tom would have been able to legally use contraception in Massachusetts, and a year before Roe, women were officially allowed to enter the Boston Marathon. And we have been running like hell ever since. Thank you. We have just a few minutes for questions. So I'd love to hear from anyone in the room. I think there's a microphone that's going to go around, and there might be folks on Zoom.
Hi, thank you. That was fabulous. My issue is that the term abortion covers removal of any fetal tissue. So that means if I've had a partial miscarriage, and I need to have an abortion, I need to have the removal of the remainder of the fetal tissue, that's considered abortion, and now it's illegal. So there's so much more that I don't know that. Did I have that right? Number one.
Yes. So the answer is yes. So those are health acceptance issues, but it is an interesting issue of medical terminology versus popular culture. The argument would be, well, so you want to exempt people who wanted to be pregnant, but lost wanted pregnancies, those health exceptions.
I don't want to exempt.
No, you don't. I'm not projecting anything onto you. Yeah,
I know.
Yeah.
But what I'm saying is that people who need it for the term is too comprehensive.
There are horror stories about those patients.
And so I think that if we change the language, perhaps around the procedures that need to be done as life-saving procedures, then maybe we can at least save some people until we can. I won't go into the rest of how I would say it, but until we can change the laws.
Yeah, I mean, I think there's two thoughts about that in the advocacy community. One is why spend all the time and legislative energy on finessing exemptions when what you need to be doing is repealing bans? Yes, and that's a smaller number of people than the people who are needing to end pregnancies for other reasons. And it's an extension of abortion stigma to say, let's just have the stigmatized procedure called abortion and not the exact same medical procedure. We'll call that the nice one, something else. So I think that people there's lots of conversation about that. Thank you.
All right, we're going to take a question from online.
Okay. So Dave Cosson asks about ERA. And the fact that the Equal Rights Amendment, if it were accepted as law, would that help stop efforts to deny abortion rights?
It's unclear with this court, no, because they just cite the dual dig in one sentence and say, oh, that's not an equal protection thing. And ironic, that's the wrong word, absurdly, in 1974, I believe, they returned, no, Geduldig 74, then 76 is GE. There was a Title VII claim making the same argument that Title VII says discrimination against, on the basis of sex and the pregnancy. And they were like, nope, still nothing. And Congress passed the Pregnancy Discrimination Act to go, yeah, pregnancy discrimination in the workplace is sex discrimination. So my response to this question is it could, but unless it said so explicitly with a court like this, they'd say, oh, that doesn't mean abortion, right? So this is the iterative relationship between culture and law. There's no bulletproof when people are like, oh, if they had only argued equal protection, well, they tried this time, right? And it doesn't, jurists with a set path are going to follow their path.
Right. Okay, I think we are out of time.
Actually, there's another question. It seems like the same thing is happening now with women and people of color. Information being determined not appropriate, high schools and colleges, changing curriculums. We have to fight like hell. I guess that's more of a comment.
That's more of a comment, but a good one to end on. And I think there are analogies there in terms of the censorship of information and this idea that if you educate people about American history, that somehow you're advancing a certain political agenda. And if you are, it's the political agenda of equity and being informed about history and making wise choices in the future. But the idea that we need censorship to hold on to a fantasy or for some people, a reality of a certain power structure that folks are holding on to. I think there are analogies there for sure. Good. I want to be respectful
to get us wrapped up. Yeah. So I was just going to say, on behalf of my WISH co-chairs, Dr. Lisa Elliott and Dr. Susanna Calkins, as well as our extended WISH committees, I just want to extend a thank you to everyone for being here. A thank you to Dr. Watson for her very insightful presentation, and your expertise today is greatly appreciated. We do have a little thank you gift for you here.
So nice.
You. And then just a special thank you to our WISH Administrative Committee, Kara Bass, Amy Hilsey, Jay Moat, Brian Roush, and Nicole Ulibri, who were really instrumental in helping us put all of their event together today. So thank you all so much. We also have our broader WISH Advisor Committee, which I also would like to thank for their input and support. And finally, we'd like to thank you all for attending today. We hope to see you at future WISH events. Our next event is a seminar with University of Michigan Professor Lilia Cortina on sexual harassment in STEM and healthcare. And that will be this spring, tentatively planned for March 20th. So we hope you can join us for that event as well. And we thank you all again and have a great afternoon.